Pushpin disclaimer. This video on the male Sigma is created for commentary, educational, and entertainment purposes.
We're now live streaming on YouTube. This is Judge Dulce Madrigal. I'm hearing cases in Guadalupe County today. Let me start with the non-custodial parent, Marco Adam Acevedo. Sir, go ahead and announce yourself with your full legal name.
My name is Marco Adam Acevedo.
Thank you. And you're in your lawyer's office on the same device. Mr. Carl Mangine, sir, if you would go ahead and make an announcement.
Yes, Your Honor. Carl Mangine. I'm representing Marco Acevedo on this matter.
Thank you. Now, the custodial parent is Desiree Nicole Chesser. Ma'am, go ahead and unmute. And if you don't have any background noise, you can stay unmuted.
Desiree Chester?
Thank you. Desiree Nicole Chester, middle name?
Yes, ma'am. Desiree Nicole Chester.
Thank you. Now I need to swear both the parties in. Mr. Acevedo, Ms. Chester, if you'd raise your right hands for me. Do each of you swear to tell the truth, the whole truth, and nothing but the truth? Starting with you, sir.
I do.
And ma'am?
I do.
Judge Deandra Coates for the Attorney General. We're here on a modification.
Okay, I've sworn you in. Now I need to tell you a few things before we get started. I may have said it before, but I'll say it again to remind you. I'm not a district court judge with a court reporter. I'm an associate judge. I've been appointed to hear child support cases filed by the Attorney General's Office Child Support Unit. They give us a digital recorder, not a court reporter, so be mindful of that. Make sure all your answers are verbal, loud enough for the recorder to pick up and the court to hear. No shaking your head or nodding. That does not record. No ahas or ahs. I need formal yeses and nos. So with all that, let me start with Ms. Coates. Go ahead and start your opening statement since you're the ones that filed this action, followed by Mr. Mangine's opening statement.
Yes, Your Honor. So we believe at this time, when we originally filed this, that there was a change, Your Honor. However, based on Ms. Chester's, we believe testimony is going to state that they're still doing their 1 week on and 1 week off. And however, she asked us to file because at the time of the filing, they were no longer doing that. But now it is my understanding, and again, we'll get this out in testimony, that they are still doing 1 week on and 1 week off. And this was put into their final divorce decree, which they're trying to modify, the final divorce decree. In the final divorce decree, there is no child support. It's that based on this fact that they're doing 1 week on and 1 week off. That is considered deviation. And based on the testimony that if they are still doing 1 week on and 1 week off, then the rule, the Texas Family Code of the 3 years with a 10% no longer applies, but in fact that there has to be a substantial and material change. And aside from the possibly they're no longer continuing it or they are, there's no other changes that I'm aware of, this office is aware of, that would qualify as a substantial and material change at this time.
And did I understand they're modifying the divorce decree, or did I?
Yes, they're trying to, we're trying to modify the divorce decree to set child support. Based on at the time of the filing, we were told that they weren't following the possession schedule anymore, so yeah.
So I followed all that. I was just not sure if they had an independent action over there with the district courts, but that's not what you're saying. This is the action they have here through your agency, Ms. Coates.
Yes. We're trying to modify the divorce decree that was signed January 8, 2021.
Okay, I get it. There's nothing else pending. Thank you. Mr. Mangine, any opening statements, sir?
Yes, Your Honor. Just a short one. My client's contention is the same as the state's. The child custody has not changed. It may have for a time under circumstances, but right now it's still 1 week on, 1 week off. Mr. Acevedo is, and it's one of the reasons I had the monthly expense statement, because he, in the 3 years since the divorce, he has a well-established budget in taking care of the home for the children as well as the children. And so right now, what he has left over is not very much money. So we contend that since nothing's changed materially as to the custody of the children in that situation, that the child support would be inappropriate at this time.
Despite the divorce decree, the ex-wife decided to try and take him to court for child support. The second, there was a temporary disturbance in their one-way arrangement, knowing he already does more than his part and unfortunately, not every judge is like the other one we have seen, but she will be unable to help the ex-wife, since she knows if she does, she will get appealed.
Okay, I'll hear more details, I'm sure, through the testimony. And also, Ms. Chester, since you're here without a lawyer, you still have the capacity of representing yourself. What I do, though, is instead of letting you make an opening statement right now to tell me what you think should happen, then you're still gonna, under oath, tell me as testimony what you think should happen instead of doing it twice. I just go straight to the chase, let the AG call you, and so you can tell me one time under oath what you want. Okay, Ms. Coates, I'll let you start calling witnesses.
Miss Chester?
Yes, ma'am.
Okay. How many children do you have with Mr.
We have 3.
And are they all under the age of 18?
Correct.
Now, looks like we filed this back in September 29, 2023. You had asked for our help, is that correct?
It had actually been filed previously before that. I don't know. I know it was like 2 years prior, but I had never heard anything from it. So that's when I had called back and they had showed me how to properly file. But yes, correct.
Okay. So my understanding is that you are asking for child support because there was a change in the visitation.
So the thing that was listed on there was, I know we were getting more time with the kids at the time. It was only like a day, but then we would go back and forth the same. The reason for the request for the modification was the fact that I did get let go from my job because of the school schedule, for the kids. So being that I do live so far away from the kids to school, they had to let me go because I was doing drop off and pick up and just waiting there in the line. So I did have to be fired from my job. So that was the reason why I had asked for some assistance.
Okay. So the visits had never changed. So you were still doing 1 week on and 1 week off.
So we were getting the kids, me and my husband were getting the kids an extra day. And so they would add up, but I couldn't tell you how many days they added up. And then it went back to being the same.
Why were you getting the kids an extra day?
There was just like stuff that was going on. I believe there was like sickness. I don't know. I don't remember which individual it was, but it was like a few days here and there.
So were these extra days?
Modification was not for the visitations. It was more because of the financial, because I did lose my job.
Okay, so the extra days weren't because Mr. Acevedo didn't want to see his children or take care of his children. It was just something came up.
Yeah, there were things that came up.
Okay. And does he get them extra days sometimes?
Not during that time, no.
Are you still married?
Yes.
Does your husband work?
Yes, he does.
What does he do?
He is an iron worker.
And you don't do like part-time jobs like Uber, DoorDash, something?
No, ma'am.
So instead of getting a new job, she decides she's going to try and drain her ex-husband any way she can and use the opportunity where she got the kids for an extra day due to outside circumstances as excuse to attempt to modify the divorce decree.
Classes, studying, and taking the kids to their appointments and stuff like that. It's very hard to.
How close?
Time job.
How close are you to graduating?
I still have 3 years.
And you can't do part-time schooling?
Part-time schooling, no. Because every time I try to look for a job, everybody's like, well, you have to either be here early in the morning or you have to be here like really late. And my husband's commute, it would leave the children unattended.
Mr. Acevedo about maybe taking them extra in that case?
We have not.
She tries to make it sound like everything is against her in this situation, and the only thing that could fix it is her ex-husband paying child support, not for the kids, but because she decided to go back to college as a full-time student and refused to get a job.
Okay, we'll move on. Mr. Mangine, do you have any cross-exam?
Yes, I have a few, Your Honor. Miss Chesser, when we got this divorce done 3 years ago, you were employed at that time, were you not?
Correct.
And you say because you had to take the children to school or pick them up, that caused you to be fired.
Correct.
Okay. And did they monitor you when you were online doing this work?
Correct.
Okay. Now, since they fired you and you decided to go back to school, and you have already testified that there's no reasonable, in your opinion, no reasonable part-time job you could have to supplement your income.
Yes, sir.
Okay. And you also claim that Mr. Acevedo, you want sort of protection against him because of an incident that happened some years before that we got the divorce. And isn't it true that that incident arose out of the fact that you had voluntarily left the house, abandoned your husband and your children for a period of time, and then suddenly tried to come back and get into the house, which caused the problem? Isn't that?
That is incorrect.
And what is correct?
So I was not locked out of the house. I was actually forced out of the house. There was a police officer that came and did make a report that day.
Excuse me, I don't mean to interrupt you, but I'm not talking about what happened when the police officer came. I'm talking about what caused the incident to occur to begin with. Had you voluntarily?
So that incident that did occur, that had nothing to do with, we were already separated for 2 years, it might have been. And the incident happened because I was a minute late dropping off our daughter. It was her birthday. I had picked her up and I took her somewhere to go and eat, and I was a minute late and he got upset about that.
Okay, when you left the house, how did you leave? You're trying to tell me that Mr. Acevedo forced you to leave the house?
Correct.
And why did he do that?
That was not the same incident that we're speaking of. So when I did...
No, I'm not speaking about the same incident. I'm saying when you left the house, whether it was 2 years before, 2 years after, why did you leave?
I didn't leave the house. Mr. Acevedo actually locked me out of the house.
And why
did not allow me to get anything, did not allow anything like that.
Okay. And why did that happen? Just because he wanted to do it?
Because he was upset.
And why was he upset?
I couldn't tell you why he was upset.
Oh my God, stop lying.
Were you having an adulterous relationship?
I was not.
You were not?
No, I was not.
I see. And so now, Mr. Acevedo and you have been involved with a 50-50 sharing of child custody. And Mr. Acevedo makes sufficient money to support these children much better than you. And he is now got a budget that really doesn't leave him any spare money. And now you think it's fair that you should be able to come in here because you lost your job, whether it was because of the kids going to school, which we have to take your word for, or not. And now you think it's fair that he should somehow give you money to help you support these kids.
Well, it was actually requested before everything was filed. So, and it was just never talked about.
Are you saying with the divorce?
I'm sorry?
Are you saying it was filed with the divorce?
Yes, it was filed with the divorce.
Yes, and we argued that at court, and you'll recall that we had a bench trial on that issue. We even had a amicus attorney to represent your children, and at the hearing, the amicus attorney recommended to the judge that we have a 50-50 custody and no child support. Do you recall that?
I do recall some of that, but I do also recall that when we did ask for documentation, as far as when she asked for the documentation to see what everybody was, if it was fair as far as income for the kids, I do remember that there was no information provided on the other party's end.
That's not true. Otherwise, we wouldn't have been able to have the trial. Secondly, the amicus attorney did a full investigation, and I know because I paid her for her services. And she did a full investigation into everybody's income. She visited your home, Mr. Acevedo's home, on several occasions. And when she came to court and testified at the trial, she recommended no child support and 50-50 custody, which the court granted. Isn't that true?
Her words were not anything
Objection,
to do
Your Honor.
her
Never
word.
responsive. Please
Okay.
answer.
You just have to answer the question, Ms. Chester. In a minute, you'll get to say whatever else you haven't been asked. But right now, you have to answer the lawyer's questions. Sustain.
Okay, repeat the question. I'm sorry.
The question was, the judge heard the testimony of all the parties, and the judge heard the testimony of the amicus attorney. And the amicus attorney, when we made closing arguments, stated that she believed that what the best interest of the children was a 50-50 custody and no child support. The judge took that recommendation along with the rest of the evidence, and she granted a final decree of divorce based on that custody issue. Is that correct?
I do recall that, yes, the amicus did say that.
I'll pass the witness, Your Honor.
Throughout this entire hearing, she has only mentioned how much she needs child support for herself, not her kids.
Okay, let me go next to you, Ms. Chester. Technically, you're your own lawyer, so you kind of get the stand and get to tell me whatever else you need to tell me that hasn't been asked strictly related to the issues before the court. So anything else you want to say, ma'am?
I did write a little statement, if you would allow me to read it.
Well, that's your testimony. Is there any objection, Mr. Mangine? I assume not.
No, I'm not going to object. We don't have a jury present, so it's...
Yeah, I'm going to give some latitude since she's not a lawyer and she's trying to get her testimony in. So yeah, you can read your statement.
I put, Your Honor, I am writing this letter to request support for my children. I'm a full-time student with previous work with a full-time work. Unfortunately, due to location of the children's school and difficulty of balancing work and school schedule, I was let go of my job to prioritize my children's education and well-being. As a full-time student, my time is divided between attending classes, studying, and taking care of my children. While I'm grateful for the opportunity to further my education, it also comes with a set of challenges, one of them being financial strain. I rely on scholarships, loans, and to cover most of my children's expenses. However, the source of income is not always sufficient to meet their needs. I have always been a responsible parent and have provided for my children for the best of my abilities. However, with the loss of my job, I am struggling to make ends meet and provide for my children's basic needs. I believe it is in the best interest of the children to receive child support from the other parent. Sincerely, Desiree Chester.
So now she wants to mention best interest, but she is the same one who refused to get a job and instead become a full-time college student, then demands her ex-husband financially support her through it. If she actually prioritized the best interest of the child, she would either get a job or give the father full custody while she does her school, rather than demanding he essentially pays even more.
Okay, here's where I come in. I think I heard that you filed for child support. One of the stated reasons might have been because you were no longer had 50-50, that you had more than 50 possession. Is that anywhere near the truth, ma'am?
That was only for a few days, but that wasn't what was written on there. The thing that was written on there was for the job.
Okay.
So when they called and asked me about it, they had said, well, is there any way that you have them not 50-50? And I was like, only like a few days, but it's not more like significant.
Well, what I'm thinking is I can only modify if there's changed circumstances. You're telling me the changed circumstances, you don't have a job anymore. But I'm trying to figure out that the job you had when you were in court in the divorce and they ordered no child support? Were you making at or near what Mr. Acevedo was making? Were you kind of on the same footing as him as income? Or-
Not at all.
And the court didn't order child support, even with your
No.
full-time job. Because it occurs to me, and Ms. Coates made the argument when we started, is that if he's got the 50-50 split still, and your changed circumstances is, okay, maybe you didn't lose the job voluntarily, or you didn't quit it, they fired you, you still have a duty to support your children. You get that, right? That both parents have the duty to support. But that you're choosing to now go get a college degree so you can't find a full-time job again to make you where you were before. It pains me to say, but if the shoes were reversed, I'd be saying the same thing. Is like, how is it fair that he supports you while you decide, or the children more, while you decide to go get a college degree for the future, when you got a duty support now, not at his expense, that you want to go get the degree? And I'd be telling him the same thing if he was here asking child support for you. You got 50-50 split. Why should she pay for you to go to school? I mean, I'm trying to figure out why that would be fair this way.
Okay. I just, while we were married, I was a homemaker. So he was the one that provided for us, and
Yeah.
I didn't do anything else.
Except I'm not giving you the divorce. I'm looking at the modification, whether you're entitled to it.
So I do remember that the Attorney General, when we did meet last time, they were like, well, your income, what it was before, was nowhere near what Mr. Acevedo was making. And when we had requested those documents, my attorney at the time did not get the documents. And so I never knew what he was making. But the Attorney General had said last time that that he was making an substantial amount, more than 3 times what I was making. So they were like, well, why didn't they modify it then?
That was at the time of the divorce?
That was the time that we just met this last March. She had said that.
Okay. Is there anything else you want to say, Ms. Chester?
No, ma'am.
Notice how she started crying the second she realized she wasn't getting the outcome she wanted. I'm sure we all know what this means, as it is a blatant manipulation tactic that a lot of them do, because it's often effective. And as we can see, it is impacting the judge here.
Yes, I'll call Mr. Acevedo, please. Would you state your full name for the court, please?
Marco Adam Acevedo.
And in the 3 years that you've all been divorced, you've maintained a 50-50 custody relationship, correct?
Yes, sir.
And you provide, now, do you own a house?
Yes, sir.
And you make monthly payments on that house, correct?
Correct. Yes, sir.
And can you tell the court what that monthly mortgage payment is?
It's $1,834, so $1,834 mortgage.
And when we had the divorce, just to clarify, Matt, when we had the divorce proceeding, which I have to tell the court was a rather lengthy pendency, okay? We did complete and full discovery in that matter, and we even did verified inventories. So it's very hard for me to accept at this time that she wasn't aware of his income. Now, maybe last March, when she attempted to go to the Attorney General, maybe that's true. I never got notice of that. But during the divorce, there was full discovery. Everything was disclosed. So each party knew what the other person had. So there was nothing amiss during that proceeding. Now, the other thing that I want to bring out is, let's talk about that incident. And I don't want to open a dirty wound and go on for hours, but could you briefly describe the reason that Miss Chester says that you locked her out of the house?
All right. Reason why is because the fact that she had committed adultery. She was basically living with another individual, had abandoned us myself and the children. And that's why I didn't allow her to come back. And she was basically trying to force her way in the house, being erratic. And I was just looking out for the safety of my children, myself, and my home.
And that led to her calling the police over to the house when she came back?
That happened several times where she would call, but the one incident that she spoke of was due to the fact that she showed up at my house with her boyfriend at the time, driving my vehicle, and I was angry, and but nothing ever happened. She came in the home and gave me my daughter, and I was upset. I'm like, what are you doing showing up here with this guy, at my home? Who wouldn't be upset about that? And she basically was up in my face, but nothing ever happened. I never touched her or anything like that. That was basically like a false accusation, and case was dismissed.
Okay, so moving on here, you have been supporting these children like a good father for these last 3 years since we've had the divorce.
Yes, sir.
Correct?
Yes, sir.
And could you kind of briefly tell the court, and you can use that document, could you summarize what it costs you per month to maintain your house and take care of your children?
Correct. Yes, sir. So basically, I get paid bi-weekly, roughly $3,700, almost $3,800 a month. Bi-weekly, I'm sorry. The amount total is, after I've spent, which is food, gas, everything in reference to my children, is roughly $7,427. And my net direct deposit monthly is what I get paid is $7,584. So there's been cases of times where, we're barely making it. I have $100, $200 in the bank. So, and all this is, like you said, this goes to my children as far as food, clothing. And I've always, make no mistake, I've always, loved my children, taken care of them and supported them. And I'm the only stable home they've had these last 3 years prior to that as well. Due to the fact that Desiree was living in 3 or 4 different residences with 3 or 4 different individuals. So like I said, I love my children. I'd do anything for them. And like I said, my whole world revolves around my children.
Your Honor, just to help the court a little, I'll summarize this. His total income per month, net income, is $7,584. And his total expenditures per month are $7,427.79. So based on those figures, he's just hitting his budget. It doesn't leave any extra money for anybody.
Okay. Any further examination of Mr. Acevedo, Mr.
Do you think there's anything you'd like to tell the court?
I'm good.
Okay, I'll pass the witness, Your Honor.
Ms. Coates, you're next.
Mr. Acevedo, at the time of your divorce, were you making the same amount are you currently, or were you making more then?
No, I was making a little less. I get yearly COLA, cost of living bump, but that's about it.
What are you making yearly?
About 123,000.
And do you remember how much you were making back in 2021?
About 110 is when I had just got hired. Like a few, I think, year or two prior, 2019.
All right. And do you pay for anything for the children extra? Even though you guys are doing 50-50 and you're not paying child support, do you send mom or the children any money, when you can? Or do you pay for their cell phones or anything extra?
No, ma'am, I'm struggling sometimes because I live basically paycheck to paycheck still, regardless of how much I make. That's it.
And are you by yourself, or have you remarried or a new girlfriend or anything?
No, ma'am, I'm still single, and like I said, my whole world is devoted to my children, and I just want them to have a good life and succeed.
And you're still providing the health and dental?
Yes, ma'am.
Okay. Your Honor, no further questions.
Technically, Ms. Chester, again, like you are acting as your own lawyer, do you have any cross-examination? And Mr. Acevedo, it has to be questions only on the issues before the court. You can't call names. You can't get into an argument. You can't be accusatory. Do you have any specific questions? I'll let you ask them. If not, we'll move on.
I do not have any further questions.
Okay, well, I don't know if Mr. Acevedo knows these, but you're the witness right now. Let me ask you generally. Do you know what she was making at the time of the divorce that was near you or nowhere near you?
Just what she stated, but I didn't really know because at the time we were separated, so she didn't really provide me that information.
Okay, well, you both didn't know, but if you had lawyers or other court people, they probably knew, even if they didn't make you aware, but I find that hard to believe.
Your Honor?
Well, I mean, I'm not saying at that time, Your Honor, that I might not have known, but I haven't reviewed the divorce.
Yeah, I know.
And I have.
Your Honor, based on her testimony, I calculated what she would have been making.
Yes, ma'am.
$46,930 a year.
Okay, does that sound right, Ms. Chester? Back at the divorce?
When we did our taxes for that year, it came out to 32 is what it came out for that year. Overtime wasn't always guaranteed, and it just depended on if they allowed us to do work a Saturday. So that was just, but it was about
my point's going to be that I can't relitigate the divorce and what they did in the divorce.
Correct.
That's a done deal with that judge, with those lawyers, with the amicus attorney for the child, whatever. But if there was a discrepancy in your income at that time, and there's a clear discrepancy now if you tell me you make zero, but that's not the standard. It's what you should have been making, because he really doesn't have to pay for your decision to go to school and have zero income. You get that. And maybe your husband should be talking to you, or you all should be figuring out if you can afford to do this, or wait till the kids are 18. But, well, tell me this. How old are the kids? I don't even know that. Tell me that.
So I have one without Mr. Acevedo that's 17. And then I have, we have a 14-year-old, a 12-year-old, and a 10-year-old.
Okay. So the three with him and an older one that's still in the house and in school?
Yes, correct.
And do you get child support?
Head off to the military, so we're doing that.
You're doing what?
He just recently graduated, so he's not in school, but he's going through the process of his military career. Okay. So he do that.
Do you get, well, if you got child support, it'll end when he's 18. That's coming up soon, or do you get child support?
I don't get child support.
I won't ask why. I just want to know if you did or you didn't. Okay. So you got the three. So I might be the kind of judge that might have given you child support, but I don't do divorces, and I was nowhere near a divorce, and I can't judge another judge for whatever they did and whatever was recommended. But what I have to see is what your situation was then and what it is now, and if there's changed circumstances. If the change was you had the child a little bit more, well, then that might have resulted in some minimal amount of support if it wasn't equal 50-50 anymore. But whatever happened wasn't much, and you're back to 50-50 is what I heard. So now the only difference I see is that you're not working at all and you were working then full time. But if you chose to stay out of the workforce to go to school, then you're underemployed. And I don't think the law would allow me to give you child support under these circumstances. As much as it might pain me to see him making 100 and you have zero, or that you had 46 at the time, 47, maybe even 32. But that's not I gotta be a hard ass. I gotta follow the law. I gotta do what I need to do. And if I don't, they're gonna appeal me, go to another judge that might say I was wrong, because I've never given child support to somebody because they're making zero. So just because you're going to school, it's not the other parent's job to let you go off to do, he could want a master's if he doesn't already have a bachelor. Could do the same thing. And how fair would it be to tell you to pay him while he goes to school? It wouldn't. So I'm still because
say
I'm
that
not
on the insurance, the kids are all under Medicaid as well. So I know that it does state that he does pay for the insurance, but the kids, all of them are on Medicaid right now as well.
I don't know if the state knew that, or is that part of this case, Ms. Coates?
Yes, Your Honor. It's a secondary. Mr. Acevedo was ordered to carry it in the divorce. And we've seen this time and time again, where you can have government insurance and then private
Have it as
to cover as a second. Yeah, so he's the primary holder. He was primarily ordered that. Now he just stated he still has it. So
Oh, he still has it. I was thinking he hadn't had it. She had to go on government assistance, but no, that's not. This is
no. He testified he still has it, Your Honor.
Has it. So there is no change circumstances on that one either.
And unfortunately, in the divorce findings, all it says is that due to current possession schedule of the parties, it's ordered neither shall pay child support at this time. There was no finding of their incomes and being offset. So,
okay. I'm still talking to you, Ms. Chester. Do you have anything else you want to tell me that could persuade me in any way?
I don't know why the judge is trying so hard to find a way to put the husband on child support, when she even admits it's ridiculous that he should be on the hook for her decision to go to college. We all know if the circumstances were flipped, she would not be affording Dad this same luxury.
No, Your Honor.
Okay, state have any follow-up for anybody, or recall Ms. Chester or Mr. Acevedo?
no, Your Honor.
No further evidence or witnesses, Ms. Coates?
No, Your Honor.
Stay rest, okay. Mr. Mangine, any follow-up with witnesses or evidence?
No, Your Honor, I have nothing further.
Okay, Ms. Chester, I know you didn't have any further testimony, but did you have any witnesses to call or any other documents for me to consider?
No, Your Honor.
Okay, we're down to closing argument. Let me start with the state, followed by Mr. Mangine, and wrapped up by Ms. Chester in that order.
All right, Your Honor, at this time we are asking for a non-suit on this matter. Unfortunately, there is no substantial change. As I stated, there in the divorce decree, it was based on the finding that they both did 50-50, which she testified they still are doing that. And as Your Honor previously stated, instead of rejoining the workforce, she went to college full-time. And it wouldn't be fair if Mr. Acevedo decided to do that and then he get hit with full child support. I think in the best interest, both parents should be working. Yes, getting an education is important to further your life and then make it better for your children. But given the circumstances, Ms. Chester should at least been part-time and found something, even door dashing. So I don't think this case qualifies for a modification at the time, as unfortunate as it is.
The only unfortunate thing is that the father had to deal with this. She cheated on him, then falsely accused him of Devi, then tried to put him on child support so she could go to college. While refusing to get a job, her decisions led her to her current situation, not his.
And on the medical support issue, did you have any argument, or you're saying the same about that? No change circumstances?
Yes, Your Honor. There's no change in the circumstances based on his testimony that he's still providing that. I didn't hear any testimony from Ms. Chester that she doesn't have it, the cards from him or anything like that. But he was ordered to carry it. He stated he's still carrying it. And again, government insurance can still be a secondary when a parent is providing private. So there is no change in this case at all.
Okay, Mr. Mangine, your closing, and make it brief, sir.
I'm going to keep it very brief, Your Honor. I completely concur with the state's closing argument. I don't think I need to elaborate on that, and so I won't waste the court's time in doing so.
Okay, Ms. Chesser, it's your turn, and you can stay off camera if you want to. I don't care, but if you want to unmute yourself and make a closing argument, you have the right to do that. A summary of what you believe I should do and why. What your position is.
So, Your Honor, I know that the Attorney General did mention DoorDash or something as part-time, and with having a full schedule as well as doing night classes and anything else, without the child being, I can't leave them alone to do any type of part-time as far as DoorDash. We are going through, me and my daughter are both going through counseling as well, so that does make it difficult to be able to do anything else. I am trying to get her through something, and I am going through counseling for domestic abuse. So it is really hard to try to get or even find a part-time job. So I just wanted to say that.
Okay, I've got to admit I heard half of it. Some of it was garbled, and I don't know why the audio is worse with your video off, or you're too close or too far from the microphone that didn't make it super clear. But I heard the word abuse at the end, so I want you to repeat whatever you said about that situation. I'm not sure I heard or understood what you meant.
So I do know that when the Attorney General did mention DoorDash or any type of part-time job, it is kind of hard to do with finding this time with doing night classes and doing. I am going through counseling for my abuse, and I am doing counseling with my daughter as well. So it's kind of hard to be able to maintain, even try to do anything with their schedule, as well as trying to get help for myself. So.
Okay, but just so you know, the standard for non-disclosure is there has to be family violence or some threats or abuse or harm or threats of abuse or harm within the past 2 years. And I know it's been a little bit longer than that since the divorce, but your original testimony did make me think that you were actually under any kind of threat from Mr. Acevedo. Do you want to either tell me something different, or are you telling me all the stuff that happened was in the time before the divorce, or did I miss something?
No, you are correct. All the abuse was while we were together. So it was before it's not the 2 years. So
it's the same thing, Ms. Chesser. If you're trying to relitigate what the divorce court didn't do or did do or whatever, I can't do that. If all that stuff happened before the divorce, this is too late for me to try to patch that up. There's nothing since the divorce. The law doesn't allow me to protect you because you don't need protecting if nothing's happened. I don't know if you get that or not. You may find some lingering harm. Well, I'm glad you're getting counseling, but it's not a current or ongoing abuse or threat of abuse that I'm seeing here at all, and I think you've admitted. Okay. Anything else, Ms. Coates?
No, Your Honor.
Anything else, Mr. Manchi?
No,
Thank you.
I have nothing further.
Okay. Yeah, it really pains me, Ms. Chester. I can see from your viewpoint how it's not fair, but the deal was you had jobs and you were both supporting your children, and that's why the 50-50 seemed to be ideal at the time. I'm sure Mr. Acevedo was fiercely fighting for primary so that you could pay him child support if he had the children up to that point, or part of the separation before the divorce. But that didn't happen either. So nobody got everything they wanted, but you can't when a household separates. You can't split the kids in half. You can't have them 100%, unless the other parent really isn't there, or gone or dies, or you terminate him. But that just doesn't happen. So you kind of both got the best of both worlds without getting shafted or getting a lot less if one of you had lost. But the deal was you were supporting the children on your dollar, or you were required to do that, and you're still required to do that. I wish the law would be clearer on that, or when or if we should allow parents to go get degrees so that they can have better incomes for the rest of the children's lives, or their lives really, because the children are older and one of them might emancipate before you finish. But that's not the way it's set up. And if I'm following the law, I can't give you child support because you're no longer working the way you're supposed to be working when the deal was struck that you get the children part-time every other week.
Notice how she isn't even hiding the fact that she's siding with a woman and just unable to do anything about it. Thankfully, this guy has a good lawyer who is able to prevent him from being taken advantage of by the system. If you enjoyed this video, I promise you'll enjoy this next video. I will see you there.